If someone was to set up an account that was inadequate or not set up an account at all without getting approval from, obviously, if they didn't set up one, they wouldn't get approval from Medicare. But if setting up something on your own, if it's inadequate or you don't do it, then that exposes potentially that client for Medicare to come back and say, you spent our money when you should have been using settlement money from the for the car crash, for example. Okay.
Yes.
And so that exposes them. And I think that most of our attendees would say that the likelihood of that particular client having the money at that time may be slim. Okay. So can Medicare pierce through the client who actually got the benefit to the plaintiff law firm?
Yes, Medicare can. The statute and the current regulations that are on the books that admittedly do not talk about MSAs, but talk about this notion of conditional payments, which attorneys should be very familiar with for past medical expenses. When Medicare is making payments for future medical expenses for beneficiaries that are not Medicare's responsibility, and instead there is another party responsible for those bills, i.e., the injury victim who settled a liability insurance case in the past, Medicare could and is doing classifying those payments as conditional payments and then seeking reimbursement of those from the responsible party. Now, what's critical to understand about the nomenclature here, as far as calling those conditional payments, is that is what allows Medicare to potentially seek recovery from the plaintiff attorney, because they were in the line of payment of settlement proceeds. So think about how a settlement's paid out, right? Insurance carrier or self-insured entity is cutting a check to the plaintiff attorney, right? They receive that in their trust account. The firm takes their fees, costs, and expenses out, pays off any liens that are in play, and then distributes a net amount to their client, the injury victim. Okay?
Mm-hmm.
The current statute and regulations allow Medicare, if it deems that future payment for the beneficiary, the injury victim, as a conditional payment. That opens the door for Medicare to pursue the plaintiff attorney and firm directly for reimbursement of those future medical bills that they have deemed to be conditional payments.